The Constitution of the United States of America establishes our government as a federalist system. That means that our government shares power between a federal and state governments. So, federal government and state governments share powers that are specifically, enumerated when they are delegated to the or given to the federal government. And any powers that aren't specifically enumerated, or just what enumerated means something specific that imagine you could put in a numbered list. If it's not specifically delegated or given to the federal government as a power belonging to the federal government, it is reserved for the states. All of that power is reserved for the states under our Constitution. So powers not delegated or awarded essentially to the federal government explicitly in our Constitution are reserved for the state governments. And that's what it means for us to have a federalist system of government. Remember, the Constitution of the United States was originally passed as a 7-article document. So Article 7 is not something that you need to know for any other reasons, but for historical purposes. Article 7 just had to do with ratifying the original Constitution in order to make it effective to begin with. So the first six articles are the ones that you really need to know, that are all still very much in operation today. The 7th article, again, just has to do with the 9 of 13 colonies of the original 13 colonies being required to approve, i.e. ratify, officially this Constitution, which successfully happened, so that Article 7 is no longer ever needed. That was just for the original Constitution to be passed. So the Bill of Rights, the amendments, the first 10 amendments to the Constitution aren't part of this. This is just the original Constitution that was amended, i.e. changed later. The last of the 10 amendments weren't made official until December 1791, well after this original Constitution was ratified. So these original 7 articles are not going anywhere. Any amendments, can be added or changed by subsequent amendments, but this is the original 7 articles of the Constitution, and you need to know what these 6 are and what they do. So be sure to consult the reading and especially the slides for that information. Article 1 establishes the legislative branch of government. Article 2 establishes the executive branch of government. Article 3 establishes the judicial branch of government. One acronym or tool or memory device that you can use to remember that is LEJ, Labels Evoke Judgments. Or if you think of another acronym, by all means, go with that. But anything that will help it stick in your memory, you do need to know that those first 3 articles establish the legislative, executive, and judicial branches of government. That's where our system of checks and balances comes from, where different branches of government have to share power and can check the power of one another. So Article 1 contains, all of the logistics for electing our legislative branch of government. It also enumerates or specifically lists and grants their powers. So this is the part of the government, the legislative branch, that creates legislation, i.e. written federal laws. And Congress is comprised of the Senate and the House of Representatives. Article 1 explains their term limits, how they're to be elected, etc. And Article 1 includes the Commerce Clause, which you need to know about as business people. The Commerce Clause gives the federal government, I've got extensive slides on this, the exclusive right, Congress specifically, the power to legislate interstate commerce, along with international commerce and commerce with Native American tribes, but interstate between the American states commerce. And that basically has been widely interpreted by our courts, by our judicial branch of government, to include a lot of power. So it is what, is the grounds for a lot of federal legislation when it comes to business operations in the United States. So if, you try to challenge some federal legislation that regulates business operations in the United States and say, they're overreaching here, the state government should be able to regulate this, they might easily point to the Commerce Clause and say, because of, and I'll explain this in more detail when I get to that slide, because of what's called the Dormant Commerce Clause, there's an implication that anything you do that excessively burdens interstate commerce, allows the Congress to come in, the legislative branch to come in and intervene. They have that power. So Article 2 establishes the executive branch of government. That's the office of the government that enforces federal law, that executes, i.e., enforces, carries out federal legislation. The executive branch includes the executive office of the president, of course, and the United States federal executive departments. That includes Health and Human Services, Homeland Security, Department of Labor, and those secretaries belong to the cabinet of the executive branch. So the heads of the executive departments, by the way, are included in the line of succession to the presidency, should anything happen to the president and the vice president. So Article 3, again, of the United States establishes the judicial branch of government. So think Article 1, legislative, Article 2, executive, Article 3, judicial. Article 3 establishes the judicial power of the United States that shall be vested in one Supreme Court and in such inferior lower courts as the Congress may from time to time ordain and establish. So this is kind of a map of the United States federal court system that helps you visualize this hierarchy that they're talking about, with a Supreme Court of the United States at the top of the federal judicial branch of government, and inferior lower courts. There are, again, three branches of government that are established by these Article 1s, Article 2, and Article 3 of the United States Constitution. Article 4 of this original document, the original Constitution, concerns the relationships between the states, citizenship, and the establishments of new states. And that'll be important when, as business people, we are operating across state lines. So the full faith and credit clause, Section 1 of Article 4, that's important to know about as business people, is the part of the Constitution that establishes that rights that are granted in civil matters, maybe you have the right to inherit because of a deed or a will, or you have some right established as a matter of just contract. Any rights established in civil cases, civil matters in one state, in state A, will be honored by state B and all other states in the union, as will any judicial decision regarding such property rights. So basically, if you have a breach of contract case in state A and you don't like the judicial, decision regarding those rights, you can't just take it to state B and ask for them to not honor that original state's decision, because Article 4, Section 1, the full faith and credit clause, means that they have to honor those out-of-state judicial decisions. So that means if you get, for example, an order in a custody dispute or a divorce matter, you can't just relitigate it all over the United States of America, right? If you get full custody in Arkansas, Texas has to honor that. The Privileges and Immunities Clause is contained in Section 2 of Article 4, and that prohibits states from imposing unreasonable burdens on citizens of another state. So maybe for instance, we're all citizens of Texas, right? We live here. So when we go to other states, Article 4, Section 2 protects us from having reasonable burdens imposed on us by those other states, particularly with regards to our means of livelihood or doing business. So you basically can't give your businesses in your state so much preferential treatment that you are in violation of Article 4, Section 2, the Privileges and Immunities Clause. So you can't impose what are unreasonable burdens on citizens, including out-of-state businesses of another state. This applies only to citizens and not to, say, corporations or foreign individuals. So if you're trying to do business in another state, this is meant to protect your means of livelihood, your means of doing business. But if you are trying to be protected as, like, say, a corporation that's formally formed, that's been officially formed, this does not apply to you. So this applies to citizens. The test for the Privileges and Immunities Clause is the foreign state, let's say for us, maybe that would be Oklahoma, must have a substantial reason for treating the non-resident us differently, which must be substantially related to the state's objective behind the law. In other words, it can't be unreasonable. It can't be arbitrary. The Article 6, sorry, skipping ahead. So Article 5 is the amendment to the Constitution process. So that just concerns adding any amendments to our original seven article Constitution. So every single time from the First Amendment onwards, that there's been another amendment to the Constitution. Rules have been followed, including, three-quarters of the states having to ratify before these amendments were officially made constitutional, part of the Constitution. So that Article 5 concerns adding amendments to the Constitution and, changing what they acknowledge is going to be an evolving document. Article 6 concerns debts, supremacy, oaths, and religious tests. The supremacy clause is critical to know about. So in Article 6, it is established by the Constitution that the United States Constitution, federal treaties, laws, and regulations are the supreme law of the land. And the Constitution is at the top of that hierarchy there. So state and local laws can't conflict with valid federal laws. Valid meaning federal laws must be constitutional. But if there is a valid federal law and a valid state law that are both constitutional, but they are in conflict, under the Supremacy Clause, the federal law will win. And the United States Constitution is, above all, the supreme law of the land. So, Article 6 also contains the religious test clause. So if anybody ever tries to tell you that this was founded as a Christian nation, that is actually not accurate. Article 6 of the Constitution establishes that in order to hold office in this country, a position of public trust, whether it be county treasurer or president of the United States, you are not required to swear to any god. You are not required to offer spiritual collateral to anyone else's liking. You're not required to even have any spiritual collateral to offer. You just have to swear on your honor on the Constitution to uphold the Constitution. So the preemption doctrine is the doctrine that provides that federal laws take precedence over state and local law, keeping in mind that they have to be constitutional, of course. Congress may expressly provide that a federal statute or written law, exclusively regulates an area or activity. Or local governments can be given concurrent power.